Hi everyone. Today we're going to talk about the top 4 ways prosecutors abuse their power. This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Okay, so 4 ways. You and I talked earlier about ways that prosecutors often abuse their power, and people may not remember, you used to be a prosecutor yourself, so you really know from up close like what they're supposed to do. And we identified 4 main areas where they don't do the job they are supposed to be doing. So the first one was they may overcharge or inflate the charges. So what does that look like?
Right. I mean, we see that happen all the time, and it's so frustrating. A very common example of when this happens is, say that there is an allegation or someone's accused of a domestic assault, and the alleged victim is saying that she was grabbed by the arm and the throat, and that her boyfriend was threatening to push her out of the car while it was going down the road. And so instead of this just being, the incident, he grabbed her by the throat, the prosecutor will break it down into he grabbed her by the arm, so that's 1 charge, and he grabbed her by the throat, so that's 2 charges, and allegedly he tried to push her out of the car while it was going down the road. That's a 3rd charge. And so, the person's looking at, with this, instead of potentially 1 charge with the alleged grabbing her by the throat and impeding her breath, they've now turned it into 3 different charges and 2 felonies, 1 misdemeanor. And so they really just parse out every little allegation and turn it into a charge so that, the person is facing, these multiple decades in jail versus, the potential of 10 years in jail. And so it really is used as a tactic to try to intimidate the defendant into taking a plea deal, because there's this looming sentence that seems insurmountable ahead of them.
All right, so it sounds like there are many occasions where they're adding charges and then adding potential jail time. So another one that you mentioned is that prosecutors are bringing a case with insufficient evidence. And what does that look like?
Sure, they bring cases where there's insufficient evidence or they haven't reviewed the actual evidence. And I have an example of a case that you actually helped me on when we were preparing for trial. And that's where my client was in a relationship. It was a dysfunctional relationship, and he was sober, and the alleged victim was a very bad alcoholic. And they would get into these arguments, and law enforcement would often get called to the apartment. And in the particular case that he asked me to help him on, he was charged with a strangulation. That is a felony charge. And it was based on just an investigation that had gone wrong. Essentially, the rookie officer was allowed to decide what charges to take to the prosecutor. And he had 2 supervising officers who were there. And, by reviewing the evidence, I could see that the first supervising officer suggested that the parties just go their separate ways because he didn't think there was enough evidence of any sort of assault. And the second supervising officer, she believed that, there might be at least a misdemeanor battery because the alleged victim said that he pushed her into the couch while they were playing cards. And the rookie investigator was asked to, what would you charge this person with? And he kept talking to the alleged victim, kept trying to sort out whether or not my client had grabbed her by the neck, had impeded her breathing, and essentially asked these leading questions to this woman who was intoxicated and very mad, and got her to say, yes, he grabbed me by the throat and I could not breathe. That was not what her testimony or her statement would have said if he hadn't asked those follow-up questions. She was just saying that he pinned her to the couch, and my client was saying she was on top of me and grabbing my phone and throwing it, and I pushed her away. She was intoxicated, and I couldn't get her to listen to me, and I just pushed her away and told her to calm down. And so the rookie decided to arrest him for a strangulation. Now, the officers, didn't talk to the prosecutor about what they thought. The senior officers didn't talk to the prosecutor, when the charges were made about what they thought should happen. They let the rookie go to the prosecutor. And the prosecutor, didn't review the evidence, didn't watch the body camera, didn't see how the investigation unfolded, and just listened to the rookie officer. Now, what the other officers knew was that just about a month and a half before this alleged incident, the same victim was overheard, because officers were called to the apartment and they could hear what was going on, and the alleged victim was overheard saying, "I'm going to tell them that you pushed me to the ground, you grabbed me by the throat and pushed me to the ground." And my client is heard saying, "But I didn't do that." And was then heard saying, "Well, good luck proving that." And so, we had to ask for all the prior contacts, all the prior reports, and unravel this and let the prosecutor know that this alleged victim had almost falsely reported, or had actually falsely reported similar conduct just 6 weeks before. But at that point in time, my client had been in jail for 4 months before I could get the prosecutor to look at it. He had lost his job. He was obviously in a position where he had to hire an attorney on a felony charge instead of, perhaps just a misdemeanor charge. And if, the prosecutor had looked at it closely, he probably would have told the rookie officer, this case has serious problems. She falsely reported this exact same thing, several weeks before, and we don't have the evidence, the physical evidence, to corroborate her story here. We, in fact, have you asking her if she was unable to breathe, and you asking her if he grabbed her by the throat. So, that rookie cop actually tainted the investigation, and had the prosecutor taken the time to look at it, we would have saved a bunch of time, money, effort, and this defendant was just a victim of a prosecutor not doing his job or not exercising his power responsibly.
Yeah, I remember that one, and that really is a great example of that, insufficient evidence and not reviewing the evidence that's there. So a fourth one would be ignoring police misconduct, relationships maybe the police have with the witnesses that they're not disclosing.
Well, yeah, there's all sorts of police misconduct that the prosecutor sometimes just hopes that the defense attorney doesn't get wind of. And, they have this great power, and with this great power, they have to be transparent. It may ruin their case, it may compromise the outcome, but they can't hide the ball from the defense attorney or the defendant. That's just the power, the incongruence of power is just too great that they have to be transparent. And I have an example where we had a married couple who was on and off again, and they were looking to get a divorce. And the wife called the police and said that my client did something to injure her. And my client, said that they were just playing around, that, they were flirting with each other, that what he did, he did not intend to do. And the police, when it comes down to it, we've talked about this before, a lot of times they're going to believe the female over the male in this type of situation. There was no physical evidence to support her claim. She had a lot of motive to make it up. They were having marital problems, and, she was getting ready to fight for the kids, but they were going back and forth with whether or not they were going to stay together. Well, after the initial call, the investigating officer maintains contact with the alleged victim, the wife of my client, and actually starts having an affair with her. So, as the case is unfolding, the prosecutor learns about this, and I actually confront the prosecutor with it. And, the prosecutor's response to me was, well, I don't think that's relevant. I don't think that plays into what happened on the evening of the alleged incident. But it really is something that I should be able to cross-examine the officer on the stand if he's testifying and then has, this additional layer of complexity. That is, now he's romantically involved with the alleged victim. And that really calls into question the credibility of his testimony. But the prosecutor didn't think that they needed to tell me that. And so even when I called him out on it. So, it really is sometimes their perspective on their responsibility versus my perspective on their responsibility. And it requires that experience and that expertise to be able to confront the prosecutor and then use that to your client's advantage.
Yeah, so that's ignoring what a police officer actually did. There's another whole way that prosecutors don't do their job right, which is just withholding evidence altogether. And what's an example of that?
Sure. I have a client who had a daughter who was, in trouble, just was going down the wrong path. She was really getting involved with older men that, were taking advantage of her. And he was at his wit's end. And on one night, when this all came to head, she had snuck a young adult male into the house. He had a sordid past. He was in trouble with drugs, and he just wasn't, your 20-year-old college kid, and she was a 18-year-old senior. That was not the dynamic. He was 20, she was 16, and he was a little bit shady. His intentions probably weren't pure. And so when the dad learned that there was basically an unknown male in his house, and specifically in his 16-year-old daughter's bedroom, he grabbed an unloaded firearm and pointed it at the young man and escorted him out of the house. Now, my client was then charged with aggravated assault. And in this particular case, I learned that the individual, and it wasn't, I asked the prosecutor for his criminal history, the alleged victim, that is the 20-year-old kid that was involved in drugs. I just wanted to know what kind of character were we dealing with, because I thought that would be relevant at trial to, talk to the jury about. The prosecutor wouldn't give it to me. I asked for police reports, any police contact this individual had had. I got a few, but the piece that I didn't get was the fact that there was a first-degree sexual assault case on the prosecutor's desk involving this 20-year-old young man and a teenage girl who had allegedly had so much alcohol she passed out, and then the allegation was that the 20-year-old male had sex with her. And so it was a sexual assault. And if I had known that, piece of evidence, and I was looking for it, and the prosecutor knew I was looking for it, we would have probably taken our case to trial. Now, the way it turned out, my client got a plea deal where he had to jump through some hoops and be on probation for a period of time, but then the case got dismissed. And so, that was just grossly inappropriate and, not okay. But the prosecutor did it, and he knew what he was doing, and he failed to give me that evidence, which that my client is entitled to. That's exculpatory evidence. That's evidence I could use at trial. I believe that I could use at trial. Now, the prosecutor may try to keep the evidence out, but that's not his job to decide. That, evidence I could have used to help my client fight the charge. And unfortunately, those things happen.
Wow, so it sounds like prosecutors have a lot of power and they don't always use it responsibly. So if someone is feeling like their prosecutor is not being fair and need an attorney, how might they get in touch with you?
Sure, we'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.